I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are bringing you compilation number 202. We will be in 4 different judges' courtrooms. Before I give you those names, don't forget to like, comment, share, and subscribe. It is going to help us out tremendously in the YouTube algorithm. Also, commentary will be left in the proceedings that previously had commentary in them. Also, chapters will be added for your convenience. I promise I will try to make sure I remember to add the chapters. I missed a couple videos, so sorry about that. And now let me give you the rundown of the judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge Laura Findorff out of the state of Colorado. Second, we will be in the courtroom of Judge Corey Wiggens out of the state of Michigan. Third, we will be in the courtroom of Magistrate William Burton Jr., also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Larry Williams Jr. out of the state of Michigan. Listen, these compilations are going great. Shout out to Sovereign Citizen Chronicles for sharing Judge Laura Findorff with me. Thank you, my brother. I appreciate you. And now, guys, there's nothing else left to do but jump in to 202.
Good morning, Your Honor.
Good morning, sir. My understanding is that you are choosing to represent yourself, correct? You're choosing to represent yourself, correct?
I am pro se with advisory counsel.
Okay.
Yes, ma'am.
Did anyone give you information as to who that advisory council was going to be?
When I called at the time, no one, they hadn't been appointed.
Okay. Do we have a list of who accepts advisory appointments? Okay, well, we'll go ahead and appoint him, and I'm going to be perfectly frank with you. The list of attorneys who accept advisory appointments is, it comes through the kind of the Office of the Public Defender. And there aren't as many attorneys as there used to be who are willing to accept advisory appointments. I do have an attorney who has been willing to accept appointments before. However, I also know that in the next few days, he will find out if he's been appointed as a county court judge. But I'm going to appoint him at this point in time. And then at your next court date, we will give you information as to whether or not he remains your attorney or whether we find out who that advisory council is going to be. Okay?
Sounds good.
Okay.
I'm
sorry.
Go ahead.
I just want to go on the record real quick.
Okay.
Okay. So I am Gregory C. Smith, Jr., appearing sui juris under the mandate of Article 6 of the United States Constitution. Pursuant to UCC 1-308 and Colorado Revised Statute subsection 4-1-308, I reserve all my rights under the United States Constitution, including the 8th and 14th Amendments, Colorado Constitution, Article 2, subsection 7 and subsection 20, the United States Code, and Colorado Revised Statutes 18-1-504 and subsection 18-6-800.3. I acknowledge the appointment of advisory counsel to assist only in procedural research and technical filing. I remain the lead inquisitor and authorized representative. This appearance is restricted to challenging jurisdiction and procedural defaults and does not constitute a general appearance or consent to the court's jurisdiction of my private person. And I'm here to address the following, which would be the sufficiency of probable cause, specifically regarding the knowing element, the domestic violence designation, Rule 41E, property concerns, bond and protection order conditions. Because this is a felony trespass charge, I assert my right to a preliminary hearing under Colorado law. The charged offense requires a knowing unlawful entry under CRS 18-4-502. The state's own evidence shows I produced a key, identified my mail, and handling my belongings openly. That conduct is inconsistent with a knowing unlawful entry and instead reflects a claim of lawful access. I need to note for the record that both CSPD office and the magistrate during advisement expressly found that there was no forced entry into the residence. CSP arrested me based on a name match and treated property in the residence as belonging to another person, creating confusion as to the identity of the person actually alleged to have committed the offense. I had a key to the residence, received mail there, and am married to a resident of the home. I understood the protection order applied to my stepson, but not the residence. The state initially pursued a violation of protection order and declined that charge. That decision reflects the absence of evidence that I knowingly violated a restriction. The same knowing element is required here. Also, the advisement was conducted by video while I was in custody, and I was not provided any meaningful opportunity to consult privately with counsel. I was in a shared custodial setting and could not communicate confidentially. That impaired my ability to understand the proceedings and protect my rights under the 6th Amendment to the United States Constitution and the 14th Amendment to the United States Constitution. But I'm not asking to invalidate the proceeding, but I am asking the court to, hold on one second here, to take that limitation into account when evaluating the reliability of the process and the current posture of the case. I move to strike the domestic violence designation per CRS 18-6-800.3. This designation is factually unsupported as there was no physical harm, injury, or verbal threat. Regarding the property, I move for an order under Colorado Criminal Procedure Rule 41E, wherein the officers conducted a warrantless transfer of my property to a non-owner and restrained party without providing an inventory or receipt, violating due process. I request a full accounting and the immediate restoration of my belongings. If such an accounting cannot be provided, I move for damages in the amount of $5,000. Finally, since the court previously found no forced entry and the VPO has been dismissed, the basis for the current bond and the trespass charge is void. I request the immediate conversion to a PR bond and release of my funds. And based on those factors, I respectfully request dismissal for lack of probable cause.
Okay. Let's start first things first. Given the nature of the charge, which is a Class 6 felony, and you are out of custody, you are no longer entitled to a preliminary hearing. A lot of what you have addressed is factually based that would be determined most likely by a jury at the end, if we get to that point, setting the matter for trial and having a jury determine whether or not the alleged facts were done as an act of domestic violence, which, just for the record, goes beyond just an actual act of violence, but include acts done as methods of coercion, control, or retaliation. And so whether or not the domestic violence tag applies would be determined by a jury if, in fact, this matter is taken to trial, with a specific interrogatory being asked of the jury to find that the prosecution has proven beyond a reasonable doubt that any act constitutes a act of domestic violence. As to the factual basis, as to whether or not you believe the charges support the allegations that have been filed against you, again, you are not entitled to a preliminary hearing. A judicial officer has already made a determination that there is probable cause to find that you did the acts as alleged. And again, to the extent that you are either not offered or choose not to take any plea agreement, that would be addressed by a jury as to whether or not the prosecution has proven beyond a reasonable doubt that you committed the charge of trespass as a Class 6 felony. With regard to any evidence that was secured by law enforcement, To some extent, that may depend on as to whether or not such evidence or those items were secured and are going to be used as evidence in the case. I just don't know enough about this to know otherwise. So what I'm going to do at this point in time, noting that you have preserved all your objections, is I'm going to set this matter for a dispositional hearing unless you're wanting to enter a not guilty plea today. I don't know. But my suggestion would be is that you spend a few moments speaking to Mr. Libby. He can advise you as to how you can get the discovery, the evidence that the prosecution has against you, that you can go over to the district attorney's office to get that information. And then also at the next court date, we will know who specifically your advisory counsel is, and they can also further advise you as to how to proceed in this matter procedurally, noting that if you take the matter to trial, you would have advisory counsel with you. But again, as you are aware, they would just be advising you procedurally how to go forward. You would be the individual who is actually conducting the trial. So we'll give you a new court date here in a moment.
And you said the preliminary hearing was, I couldn't have one.
You're not entitled.
Not entitled to one because of what now?
Because of the element of the charge and because, or I should say the level of the charge, and you have bonded out. If you remain in custody, you are always entitled to a preliminary hearing. It changes a little bit once you have posted bond. But I'm going to give you a new court date here. And we're going to set that about 4 weeks out. And if you just want to spend a few moments speaking with Mr. Libby, unless you already know how to get your discovery.
So, Your Honor, I'd be happy to speak to Mr. Smith regarding discovery. I don't believe it's been quite yet.
Okay.
But there is a process for that. And then regarding advisory council, we don't not yet, but we have anything that.
So we're going to appoint Mr. Allen as advisory counsel. If Mr. Allen is appointed as a county court judge, then we will have to change that.
Then Your Honor, I'm sold this morning, so I just stepped out and speak to Mr. Smith.
Yep, we'll allow you to do so.
Our next court date's going to be May 20th at 9 a.m.
Yeah.
Can we start going through the plea?
No, we'll wait.
Sir, Your Honor, thank you for the briefing.
Yep.
Just for the record, I've spoken to Mr. Smith. I received this email, maybe sending us some detailed instructions regarding discovery. I let him know the sending was probably around lunchtime today to ensure they're comprehensive.
Okay.
We're also going to set the time to speak about the case. I let him know that I'd be moving in his advisory council on communications, whatsoever it ultimately ends up being. He's going to look at that again. Mr. Smith, I think we should address the issue of his bond. He wanted to have his security bonds converted to a PR bond. I let him know that I'd be objecting to that, but I also let him know that we did want to likely he was already something.
Okay.
And only because there's been some conflict between myself and the bondsman, wherein I've pretty much been threatened to that my bond would be revoked. That I was requesting a emergency PR bond. I've since my release, I've been to court, not a threat to myself nor society. Again, the DV designation is just an enhancer. There was no physical threat, injury, hurt, harm, or verbal threat to anyone. And so based on those grounds, I'm requesting a PR bond.
Well, again, for purposes of addressing bond, where there has been allegation of domestic violence. Again, understanding reserving all your arguments as to why you do not believe that domestic violence tag should be appropriate. This is a VR Victims' Right Act matter. The victim would have the right to address the court as to whether or not this should be converted to a PR bond. I'm not, if your bond gets revoked, that is something that we could address at a later point in time, but the court's not going to revoke your bond or convert the cash surety bond to a personal recognizance bond at this time. But if something changes to where your bondsman asked to get off the bond, we can address it at that point in time. All right. So
But my only concern is that if the state cannot provide the evidence of my knowing intent today, then.
But sir, all those elements have to be addressed. Those are elements of the case, which, because you're not entitled to a preliminary hearing on the element of knowing, that is either resolved by way of a plea agreement, or it's resolved by way of a trial as to whether or not the prosecution can prove that element.
Okay.
So,
Understood.
but I appreciate you raising those issues, and we can address them at a later point in time.
Thank you,
Right?
Your
Thank you, sir.
All right.
This is case number 26819FY. Ms. Dull appears on behalf of the people. Mr. Leffers appears in the courtroom but refuses to enter the well. I do remember this from the last time we were here last week. The court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right.
Your Honor, is the court going to reset the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments under the United States Constitution. What say you, sir?
I addressed you last week about about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case, which once again is why Article 3, Section 2, Clause 2 of the Constitution exists. The state cannot prosecute this because it always going to rule in favor of itself. That's the law. Also, discovery hasn't been met because I was never given a full accounting about the bond relationship and the accounting on the the bid bonds, performance bonds. And I am not a 14th Amendment citizen. I am a Michiganian, state national. I have corrected my status. I have spent a year doing it.
What do you mean by that? No, you tell me what you mean by that. I don't need you to look at paperwork. You said you corrected your status, so what do you mean by that?
Upon finding out about jurisdictions, 14th Amendment citizen is bound by your jurisdiction, sir. I am not a 14th Amendment citizen.
What are you?
I'm an American state national.
And what is that?
That is a man or woman born to the state in the territories of the Confederation of the Republic that made up this wonderful place and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the US Constitution.
No, sir, this predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Yes.
Supports it.
In the First Amendment, we are one. This is my wife, Jelaine. She's been with me for 24 wonderful years. She has had my back. She has helped me grow and understand and overstand so many wonderful things. The Constitution is set up to protect rights. And I have the right to use everything at my disposal. The Constitution is at my disposal, in addition to the supreme law of the land. So is the Bill of Rights. Not to be in dishonor.
How does the Michigan Constitution play against the US Constitution?
The Michigan Constitution, as wonderful as it may be, is not a Constitution. The corruptness that went into it destroyed it. Though it may hold some lingering truth, if you change 10% of 100% of the story, you have deceived everyone that you tell that story to. And they will never be able to defend themselves properly. They will never know how to manage themselves properly. If the truth was to be told, then the decision, the rightful will choice would fall on the people. And I am one of the people. Which is why there's also another conflict of interest. The state cannot prosecute me because I am the people. So is my wife, and so are our children.
So it's your belief that the state cannot prosecute criminal laws against its citizens. But if you were a citizen of Texas and violated a Michigan law, would the court then be able, or would the state of Michigan then be able to prosecute that person?
State of Michigan. The Texas.
No, hold on. It's Mr. Leffers is the one who has.
Well, as I stated,
We are one in our
First
creed.
Amendment right.
Okay. Mr. Leffers is the one who's before the court. Mr. Leffers is the one who gets to speak on the record.
That would be against my First Amendment right.
Okay, I can see how this is going to go. So, Mr. Leffers, you are not releasing any rights that you have. But we're going to reset this then for another probable cause conference next week. And hopefully by then we will have counsel appointed for you and you can discuss your issues with your appointed attorney.
So I do not accept. Also, I am here on special.
All right, Mr. Leffers,
In the case.
Mr. Leffers, you need to stop. All right. I need you to go out to the front window where you checked in and get a copy of your next court date, because I'm not going to allow you to interrupt the business of the court. And as you can see, you're getting pretty close to that. I'm not saying that you're wrong. I'm not saying that you're right. I'm just saying, again, this is not the forum. That's not what we're here for today. There's a procedure to go through for motions to be filed and to be heard. And as I said, I've appointed counsel, even though that hasn't happened yet, to make sure that you are fully apprised of all the options, the way the court works, the way the laws interact with each other. And I highly encourage you to listen to that counsel, that attorney, once they're appointed. You're not the first one to have this situation before the court. You're not the first one to assert these rights, but there's a way that things work, and your grasp of it right now, I believe that you are mistaken in how the laws interact with each other and how the constitutions interact with each other, how jurisdiction works. So once again, I'm going to ask you to go out to the front window where you checked in. I understand you're not waiving any of your rights, but I'm going to ask you to the front window where you checked in and get your next court date. And then we will have, again, we will continue working on getting counsel appointed for you.
Judge asked.
No, grab it yourself. It's on you.
Thank you, sir.
Thank you.
Have a nice day.
You too.
Yeah, well. So.
Mr. Reynolds?
Judge, what was that preliminary exam date? You said 12/27 and then 1.
January 3rd.
And yes, we're ready,
Mr.
Judge.
Reynolds?
Yes.
Okay, Mr. Reynolds, state your name.
Your Honor, if I could probably clear this up, Mr. Reynolds is objecting to a video arraignment at this time.
Mr. Reynolds, state your name. Irvin Reynolds. This is case number 240608. Mr. Reynolds is being charged with count 1, felonious assault. Did make an assault upon Elisa Jordan Smith with a dangerous weapon, and a pistol, without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to MCL 750.82, a 4-year felony and or $2,000 fine. Count 2, weapons felony firearm. Did carry or have in his possession a firearm, with a pistol at the time he committed the attempted to commit a felony, to it felonious assault, contrary to MCL 750.227B, 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device. Count 3, domestic violence. Did make an assault or an assault and battery upon Elisa Jordan Smith, an individual with whom he had a dating relationship, contrary to MCL 750.81 subparent 2. That's a 93-day misdemeanor and or $500 fine. A consecutive sentence may be imposed on MCL 750.506 sub small a if the assault was committed in a place of confinement, as well as habitual second offense notice. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
And again, Your Honor, Sydney Rushing, P78830, on behalf of Mr. Reynolds. And again, Your Honor, I'd just like to advise the court, my client is objecting to a video arraignment. He would like to be arraigned in
Noted for the
person.
record. Noted for the record. Bond recommendation, Mrs. Coyle.
Your Honor, based on, he's currently on a parole hold. He has a parole violation, is returned to MDOC for he has a murder 2 out of 1992. He got 25 to 40. He was paroled in April of this year. This occurred in October of this year, as the court notes. It's highly assaultive, threats of death, with a weapon. The complainant's statements are corroborated by the officer noticed a scratch under her chin. Also, they found the weapon in the backyard where he was detained once he fled from the officers. So for these reasons, Your Honor, although I know he's on a parole hold, he's likely going nowhere based on the allegations, based on the assault of nature. And I believe my guess would be the violation is the new case, but I'm not sure. So I'm going to ask for a $50,000 cash surety and a tether if he is released, tether house arrest. But likely, I have a feeling this is what the parole is about.
Ms. Rushing?
Your Honor, we'd be asking Your Honor to consider a lower bond. That is an unaffordable bond. Again, my client is located at the Michigan Department of Corrections currently. So we're asking you for consider a lower bond. I believe a GPS tether is the least restrictive means if Mr. Reynolds is able to be released prior to the conclusion of this case.
Okay, for clear, convincing reasons, I find Mr. Reynolds a danger to the complaining witness and to the community. Based on a review of the investigator's report, there was an assault with a pistol. And then what is troubling, in the last sentence of the first paragraph, the victim stated, "He has my gun and he said he's going to kill me." And given his prior murder conviction, I believe he has great ability to carry out the threat. And so for those reasons, I find he's a danger to the community. I'm going to adopt the recommendation of the people, a $50,000 cash surety. While his case is pending, he's not possessing handguns, firearms, other dangerous weapons, no contact with Lisa Smith. If he's able to post bond.
Excuse me, Your Honor. Excuse me, Your Honor. I don't mean to be rude and interrupt, but
it's too late for that. It's too late for that.
Well, I mean, y'all got a whole other thing going on here. She don't represent me. She not my.
Okay. Give me one moment. Woo! Fun Friday. Okay. Okay, Mr. Reynolds, I just want you to listen. You were given a $50,000 cash surety bond, which is, I presume, an unaffordable bond. I find that you're a danger to the community. You'll have a bond redetermination hearing Monday, December 23rd, in front of Chief Judge McConical. Well, you have a bond return. That's 9 a.m. in front of Chief Judge McConical. Probable cause, December 27th, preliminary examination, January 2nd, in front of Judge Sabri. You have any questions regarding your bond conditions and or court dates?
I have a question concerning, what is this proceeding? Is this an arraignment?
Yes.
This is an arraignment?
You just been arraigned.
Okay, the thing I'm trying to explain is, she not my attorney. She don't represent me. Okay. She been speaking on my behalf, and she not my attorney.
All right, who's your attorney then?
I'm representing myself, and I'm making a special and limited appearance.
What's your bond argument? What's your bond argument?
I don't have a bond argument. I'm making a special and limited appearance, just to challenge the subject matter jurisdiction of the court. And I'm telling you, this court don't have jurisdiction of the principal subject matter, which is the attachment action that the prosecutor filed.
Well, guys, we've come to the end of that first proceeding before Judge Burton. And as we can see, like I told you guys in the beginning, that Mr. Reynolds is facing some very serious charges. As we can see, he did a murder bid in the past. And because of what he is in court for now, he is now in jail on a parole violation. Judge Burton has deemed him to be a danger to the community. So even though he's in there on a parole violation, which he probably won't be able to get out, because of the parole violation until that's settled. They still want to make sure that they have a bond there just in case, because Judge Burton says, listen, he's a danger to the community. I don't think he should be out. With his past history, with his current history, we see he keeps talking about wanting to be arraigned in person for whatever reason. And it's probably to do with some type of, maybe something he feel he knows or understands about the law, or it could be some type of sovereign citizen thing. So with that being said, guys, let's go ahead and let's jump into this second proceeding.
I think we're ready to roll. The gentleman that's in the Michigan Department of Corrections facility, can you tell me your name?
My name is Irvin Reynolds.
All right,
and,
thank you.
I'd like to say that coming in, that I'll make a special and limited appearance just to challenge the subject matter jurisdiction of the court. And I'm saying that the court doesn't have jurisdiction of the principal subject matter, which is the writ of attachment that the prosecutor's office filed.
All right, your objection is noted. 1 second here. All right, this is State of Michigan versus Irvin Reynolds, case 24060877001. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Good morning, Judge. Steve Vincent for the people, P71917.
Good morning, Jessica Shipe, number 81798. On behalf of Mr. Reynolds, sir, can you please state your full name for the record?
She's not my lawyer, Your Honor. This is an arraignment proceeding, right?
Mr. Reynolds, do you wish to represent yourself?
Is this an arraignment proceeding?
This is sort of like an arraignment. This is like a you are arraigned, and this is a hearing to see if the bond.
Hold on, you said I was arraigned?
Okay.
Did you just say I was arraigned?
Your Honor, may I step in? I see some notes here.
Well,
I haven't been arraigned.
Can I stop everybody right now? Ms. Shibe, if Mr. Reynolds is indicating that he's not your attorney, then I'm going to ask that you hold tight right now. Mr. Reynolds,
I haven't been arraigned.
Sir, listen to me for a second. I'm trying to straighten this out. You indicated that you have not been arraigned?
Mm-hmm.
All right, 1 second. Let me take a look at what's in the file. Hold tight.
Yes, and I do have notes, so not on behalf of him, just to help the court.
I appreciate that. But let me see where we can get to. Hold tight, Mr. Reynolds. I have to look something up real quick. All right. So the system says that it was arraigned, but if that's a mistake, Ms. Shibe, you indicated that you had some additional notes.
Yes, so the notes that I have, it looks like Mr. Reynolds did want to represent himself. He was spoken to and told his rights and all. And it looks like he was okay, it looks like he was objecting to being arraigned without being brought in person. It says that he wanted to be arraigned in person and he was objecting, but I do see that a bond was given and new dates were given. So it said no video arraignment. So I believe it was done without, he wanted to come in person.
Well, I would say this, Mr. Reynolds, I would say this, that's fair. If you want to be arraigned in person.
Hold on, wait a minute.
No, stop. You have the right to be arraigned in person.
They cut
Listen to me. I'm going to stop your audio because you're not listening to me, and I'm not going to go back and forth with you. I'm indicating if you want to be arraigned in person, I am going to order you arraigned in person. And we're going to stop all this. If you stop talking over me, we wouldn't have this back and forth. All right. So I'm going to set an arraignment date. Let's see, today, the next date they have in front here for, looks like there's an exam date scheduled for January 2nd, 2025. We're going to have the writ signed for you to be arraigned on that date. We'll see if that's enough time to transport you to 36th District Court for your arraignment and then we'll take a PCC from there. So we'll schedule this for an arraignment January 2nd, 2025 before Judge Sabri. That's going to be your next date, and we're going to have a writ to bring you down to 36 for that hearing.
Well, guys, we've come to the end of both of these proceedings. On the second proceeding, not a whole lot to comment on, but I will say Judge Larry Williams Jr. handled himself well. Had to pretty much shut Mr. Reynolds down for his own benefit because, you know, he constantly was talking about he hasn't been arraigned, which technically he had been. But like Judge Williams said, he has the right to be arraigned in person. So that's what they're going to do on his next appearance. Hopefully we can get that appearance. And if we get it, as always, we will most definitely share it with you guys. But with that being said, guys, once again, as always, don't forget to like, subscribe, and share. This is Sovereign Citizens Hall of Fame. This is also Sovereign Citizens Court, guys. And for now, Sovereign Citizens Court is adjourned. I'll see you guys soon. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.